In a packed courtroom, a judge's mocking laughter echoed as he dismissed a black teenager's plea, seeing only a kid out of place. Moments later, that same judge sat speechless, his gavel still, as the teen revealed a legal brilliance that turned the case, and the judge's world, upside down. Isaiah Turner, a 19-year-old from Augusta, Georgia, stood before Judge Harold Vance in the Richmond County Superior Court, his hands clasped tightly in front of him. At first glance, Isaiah looked like any other young defendant, black, dressed in a borrowed suit, facing charges that could derail his future. But Isaiah was no ordinary teenager. Beneath his calm exterior burned a mind honed by years of self-study, a prodigy who'd mastered the law, while his peers were still mastering algebra. Today, he was defending himself, a decision that had already drawn smirks from the prosecutor and a raised eyebrow from the bailiff. Judge Vance, a white man in his late 60s, had presided over this courtroom for decades. Known for his stern demeanor and quick rulings, he carried an air of unassailable authority. But whispers followed him. Accusations of bias, of harsher sentences for Black and Latino defendants, of a worldview shaped by a different era. Most never challenged him. His robe and gavel silenced dissent before it could form. Isaiah, though, was about to change that. The case was simple on its face. Isaiah faced charges of trespassing and disorderly conduct, stemming from an incident at a local community center. The police report claimed he'd refused to leave a restricted area and argued with staff. Isaiah's version was different. He'd been tutoring younger kids in a study room, a space he'd used for months with permission, when a new employee, misjudging him, called the cops. The truth lay in the details, and Isaiah was ready to fight for it. The morning session began with the usual hum of court business, attorneys shuffling papers, defendants whispering to public defenders, the gallery half-filled with families and onlookers. Isaiah's case was third on the docket, a minor matter compared to the felonies that followed. When his name was called, he stepped forward, his voice clear. Isaiah Turner, representing myself, Your Honor. Vance looked up from his notes, his glasses perched low on his nose. He peered at Isaiah, taking in the young man's age, his race, his lack of counsel. A chuckle escaped his lips, sharp and dismissive. Representing yourself, son, he said, his tone laced with amusement. You sure about that? This isn't a game show. The gallery tittered, a few spectators exchanging glances. The prosecutor, a woman named Karen Ellis, hid a smile behind her hand. Isaiah didn't flinch. Yes, Your Honor, he said, his voice steady. I'm prepared to proceed. Vance leaned back in his chair, his chuckle turning into a full laugh. Prepared, huh? All right, boy, let's see what you've got. But I ain't waste my time. The word boy landed heavily, its weight unmistakable. Isaiah's eyes narrowed slightly, but he said nothing, pulling a neatly organized binder from his bag. Karen Ellis stood to present the state's case. She outlined the charges: Isaiah's alleged trespass at the community center, his refusal to leave, his aggressive behavior towards staff and police. She cited witness statements and the officer's report, painting Isaiah as a troublemaker who'd overstepped his place. We request a fine of $750 and 30 days of community service, Your Honor, she concluded, confident the case was airtight. Vance nodded, his eyes still on Isaiah, amusement lingering. All right, Mr. Turner, he said, emphasizing the name with mock formality. Your turn. Impress me. The sarcasm drew another ripple of laughter from the gallery. Isaiah opened his binder, his voice calm but resolute. Your Honor, the state's case relies on incomplete facts and mischaracterizations. I was at the community center on March 3, 2023, with the express permission of the program director, Ms. Angela Hayes, to tutor students in a reserved study room. I've submitted a sworn affidavit for Ms. Hayes confirming this. He handed a document to the bailiff, who passed it to Vance. Vance glanced at the affidavit, his smirk fading slightly. Isaiah continued. The prosecution's witness, Mr. Robert Klein, was a new employee unfamiliar with the program. He assumed I was unauthorized without verifying with Ms. Hayes. This assumption led to the police being called, despite my compliance with all requests to identify myself. Ellis shifted in her seat, her confidence wavering. Isaiah's delivery was precise, his arguments rooted in fact, not emotion. He cited case law, Georgia v. Simmons, 2004, to argue that trespassing required intent to violate property rights, which he lacked. He referenced State v. Carter, 2018, to challenge the disorderly conduct charge, noting that verbal disagreement didn't meet the legal threshold for tumultuous behavior. Vance's amusement was gone now, replaced by a frown. He leaned forward, flipping through Isaiah's affidavit. "You're telling me you've got case law memorized?" he asked, his tone skeptical but curious. Isaiah nodded. "Yes, Your Honor. I've studied Georgia statutes and precedent for 2 years. I also have a motion to dismiss based on lack of probable cause, if the court will hear it." The gallery went quiet, the spectators sensing a shift. Ellis stood, objecting. "Your Honor, this is highly irregular. The defendant's not an attorney, and his so-called motion is." "Sit down, Ms. Ellis." Vance interrupted, his eyes locked on Isaiah. "I want to hear this." He took the motion, a 3-page document typed in perfect legal format, and read it silently. Isaiah waited, his posture unchanged, his binder open to his next argument. The motion was a masterclass in legal reasoning. Isaiah argued that the police lacked probable cause to arrest, as the trespassing claims stemmed from Klein's unverified assumption. He cited Terry v. Ohio, 1968, to challenge the officer's escalation and included a timeline of events corroborated by Ms. Hayes and 2 students present that day. He'd even obtained security footage logs, which he offered to subpoena, showing he'd entered the study room with a key provided by staff. Vance set the motion down, his face unreadable. "You wrote this yourself?" he asked. Isaiah nodded. "Yes, Your Honor. I've been studying law since I was 16, self-taught through public library resources and online case databases." Vance's jaw tightened, a flicker of discomfort crossing his face. He'd underestimated Isaiah, and the room knew it. Ellis tried to recover, arguing that Isaiah's youth and lack of formal training made his motion unreliable. "He's playing at being a lawyer, Your Honor," she said, her voice sharp. "The state's evidence is clear." Isaiah countered immediately, citing Florida v. California, 1975, which affirmed the right to self-representation. "The Constitution doesn't require a law degree, Your Honor," he said. "It requires competence, which I've demonstrated." Vance leaned back, his fingers drumming on the bench. He'd laughed at Isaiah, called him boy, assumed he was another kid caught in the system's churn. Now, he faced a teenager who'd outmaneuvered a seasoned prosecutor and cited Supreme Court precedent with ease. The judge's bias, laid bare by his earlier mockery, hung heavy in the air. "I'll take the motion under advisement," Vance said finally, his voice clipped. "Mr. Turner, you've made your point. Ms. Ellis, I expect a response to this motion by tomorrow morning. We'll reconvene at 10 a.m. He banged his gavel, signaling a recess, but his eyes lingered on Isaiah, a mix of irritation and respect. Isaiah gathered his papers, ignoring the stares from the gallery. A few spectators whispered, impressed. Others, skeptical, assumed he'd gotten lucky. Ellis packed her briefcase, her face flushed, already planning to discredit Isaiah's arguments. But the momentum had shifted, and she felt it. As Isaiah left the courtroom, a woman approached him, Ms. Angela Hayes, the community center director. She'd been in the gallery, watching silently. "You did good, Isaiah," she said, her voice warm. "I'm proud of you." Isaiah smiled, a rare break in his composure. "Thank you, Ms. Hayes. I'm just getting started." Back in his chambers, Vance sat at his desk, Isaiah's motion in hand. He'd ruled on thousands of cases, but none had unsettled him like this. The teenager's brilliance was undeniable, but so was Vance's own misstep. His laughter, his use of boy, had been recorded by the court stenographer, preserved for any appeal. He knew the optics were bad, a white judge mocking a black teen, only to be schooled in open court. He'd need to tread carefully tomorrow. Isaiah spent the evening at the public library, refining his arguments. He'd anticipated Ellis's counter, likely a push to admit the police report as sufficient probable cause, and prepared a rebuttal citing Wong Sun versus United States, 1963, on tainted evidence. He worked late, fueled by coffee and determination. This wasn't just about his case. It was about proving he belonged, that his mind could bend the system to truth. The next morning, the courtroom was fuller, word of Isaiah's performance spreading. Local reporters sat in the gallery, notebooks ready. Ellis presented her response, arguing that the officer's good faith belief in Klein's complaint justified the arrest. She urged Vance to deny the motion and proceed to trial, framing Isaiah's arguments as clever but untested. Isaiah stood, his voice clearer than ever. He dismantled Ellis's response, point by point. He argued that good faith didn't override objective facts, citing Beck v. Ohio, 1964. He introduced a new affidavit from a student witness, corroborating his timeline. And he pressed for the security footage, noting the state's failure to produce its suggested exculpatory evidence. Vance listened, his pen still. Ellis's arguments, once solid, now seemed hollow. The judge knew he couldn't dismiss Isaiah's motion without risking reversal, or worse, public backlash. At 10:32 a.m., he ruled. "The motion to dismiss is granted," he said, his voice flat. "The state has not established probable cause. Charges against Mr. Turner are dropped." The gallery erupted, murmurs turning to applause. Isaiah exhaled, his shoulders relaxing for the first time in months. Ellis sat, her face pale, her case gone. Vance banged his gavel, restoring order, but his authority felt diminished. He addressed Isaiah directly. "Mr. Turner, you've shown remarkable ability today. The court acknowledges your efforts." The words were grudging, but they came. Isaiah nodded. "Thank you, Your Honor." He packed his binder, his mind already on the future, law school, a career fighting for others like him. As he left, reporters swarmed, asking about his story, his self-education. He answered briefly, crediting the library and mentors like Ms. Hayes. Vance returned to his chambers, the weight of the case lingering. He'd misjudged Isaiah, let bias cloud his judgment, and paid for it in open court. The reporter's presence meant scrutiny, and he knew his words would be quoted. He'd survive, but his reputation wouldn't emerge unscathed. Isaiah's victory rippled through Augusta. The community center honored him. The library featured his story in a newsletter. Law schools took notice, scholarship offers arriving. But for Isaiah, it was simpler. He'd faced down a judge's laughter, a system's weight, and won. He'd proven his worth, not just to Vance, but to himself.